If you're a business owner, is it possible that your business may actually be divided as a part of your divorce? And if so, do you need to get your business appraised? Like many of my answers before, the short answer concerning a business appraisal is maybe. Do you need to have your business appraised? Quite possibly yes, though it's going to be determined on a handful of factors. No different than many videos before. As you know, the court has the ability to divide up only the community assets within a divorce. As a reminder, the court is going to presume that anything acquired during the course of the marriage is community property, therefore goes into the pot with which the court can divide. If you want to prove that something is your separate property, you have to show the judge that it was acquired prior to marriage or that it was done during marriage through gift, devised descent, or possibly a personal injury award. If you got in a car accident, that money is yours. With that being said, it's quite possible that you started a business during the course of your marriage. If you started a business during the course of your marriage, it may be possible that your portion of that business, if you two have business partners, may be part of the community pot to be divided. In that instance, don't be surprised if a business valuation needs to be done to determine exactly what your share of the pie actually is. If a business appraisal is done, it's likely that a third party is going to be hired, possibly by some sort of CPA firm, to determine the value of your slice of that business pie. That business evaluator is going to look at profit and loss, they're going to look at assets and liabilities, and anything and everything that has to do with your business. Moreover, that business evaluator is going to determine how much of that business pie should be put forth in the community pot. No different than the separate and community property arguments we've had in the past. If you started your business prior to marriage, the business in and of itself may be considered, or at least your portion of the business in and of itself may be considered separate property. However, if you are making profits that are then subsequently being used for the community, that portion may end up going into the community pot. In other words, if you're paying yourself as a W-2 earner through your own business, those are community dollars. It's income received during the course of the marriage, no different than if you were a W-2 employee elsewhere, not through a business that you have an ownership stake within. Thanks again for watching. If you have any questions or comments, feel free to leave them down below. For more family law content, feel free to subscribe and feel free to visit our website at familytexas.com.